further hearing in the appeal, Lachaux and the Independent Print Ltd and another.
Yes, Miss Page. Good morning.
Good morning. In my 28 minutes, I am, if I may, going to just say a few concluding remarks and then hand over to Mr. Basutil on section 1.2. Obviously, if there are any questions, the first point I want to make is just to add something on this point about Lord Justice Davis concluding that what Parliament intended was to give statutory effect to Thornton, but raise the threshold to one of serious substantiality. The appellants agree that if Section 1 is, as I put it, Thornton plus, then once the court has made the findings of fact on meaning and whether defamatory, the cause of action is complete. Can I just ask you to go to the case for the appellants at paragraph 30. It's in Core Bundle Volume 1, and it's at electronic page 73, hard copy page 71. It's at paragraph 30, and what Mr. Price says here is the conclusions of Lord Justice Davis are set out in the subparagraphs of 82. The most significant is at 1, which states that Section 1.1 has simply given statutory status to Thornton and raised its threshold from substantial to serious. If this conclusion is correct, the Section 1 hurdle will be satisfied solely by the seriousness of any imputation conveyed by the words by operation of the common law principles for determining meaning. The remaining conclusions in 82 consider the possibility of a further issue of serious harm after meaning has been determined. But if Section 1 is simply an enhanced version of Thornton, there will be no further issue for determination. Everything will turn on the seriousness of the imputations found at the meaning hearing. So if we are right that to invite you to uphold the conclusion of Lord Justice Davis about giving statutory status to Thornton, then the parties are agreed that the cause of action will be complete and that his various statements that suggest that there's still something to argue about or that the defendants could defeat the cause of action are not correct. Next, and of course, the problem then does not arise on our construction or on the construction of Lord Justice Davis on that point of one having to impute to Parliament an intention that the limitation period for libel starts to run on publication, but the cause of action is not yet complete. So that is the answer to that conundrum. Next, I wanted to just invite you to look at a couple of passages in Ratcliffe and Evans, because we haven't really looked at authorities at all. That is in Volume 1 of the Authorities Bundle, Part 2, tab 27. And I wanted to start at Electronic Bundle, page 1044, hard copy bundle 542. This was an
Sorry, can you give me the tab number again? 37.
Yes, sorry, tab 27.
Thank you.
This was an action brought in respect of words that were held not to be defamatory. They were words that falsely imputed that the claimant had closed down his business. Well, that wasn't defamatory, but it was false and malicious and damaging. So it became, after it was held not to be defamatory, it then proceeded as a malicious falsehood claim. And of course, this was prior to Section 3 of the Defamation Act 1952, which would have provided actionability. And just a couple of passages which demonstrate the distinction between actionability per se and how the presumption works in the remainder of defamation. If one goes to page 1044, 542 of the hard copy, at the bottom of the page, about 6 or 7 lines up, that an action will lie for written or oral falsehoods not actionable per se nor even defamatory, where they are maliciously published, where they are calculated in the ordinary course of things to produce, and where they do produce actual damage, is established law. Such an action is not one of libel or of slander, but an action on the case for damage willfully and intentionally done without just occasion or excuse, analogous to an action for slander of title. To support it, actual damage must be shown, for it is an action which only lies in respect of such damage as has actually occurred. And then just going to about 3/4 of the way down the page, a sentence that starts in the middle, about 1/3 of the way up, but where no actual and positive right apart from the damage done has been disturbed, it is the damage done that is the wrong. The expressions of special damage, when used of this damage, denotes the actual and temporal loss which has in fact occurred. And then just finally over the page, to 2 pages, electronic 1047.
What do you understand the phrase actual and temporal loss to mean? It's effectively pecuniary loss, is it?
It is something that is estimable in money. So
Yes.
it could be that someone decides not to take you out to dinner, and that is estimable in money. You've lost the value of that.
You know, it's the loss of money or money's worth.
It's a loss it's a detriment that can be calculated in money in the loosest sense of the word. We've given the various examples of it, and it includes the husband walking out on the wife after being told something about her that he didn't know.
Well, all damage is calculable, and general damages calculation may not be quite the right word for it. It results in a money award, dependent on an impressionistic view of the scale of the damage suffered to the reputation. But, I mean, we're talking here about something that you can specifically prove, so to speak, with vouchers.
But in defamation, actual per se, the damages are at large. It is not an attempt to compute
Yes,
loss.
I'm just looking at what you understand by actual and temporal loss, which has in fact occurred. This is a provable pecuniary loss. It may take the form of a loss of opportunity, but it's pecuniary.
It isn't pecuniary. It's not a special damage claim in the sense of being pecuniary. It is something where you can say that you have lost something that is estimable in some way in money. You've lost some advantage, a temporal advantage. It is much looser. I'll ask Mr. Basuto to find the reference in our case where we've explained what it is. It's much looser than it's special damage as in pecuniary loss. And then the last passage, at the top of page 530, akin to, though distinguishable in a respect which we mentioned from actions of libel, and that distinction doesn't matter for present purposes, are those actions which are brought for oral slander, where such slander consists of words actionable in themselves, and the mere use of which constitutes the infringement of the plaintiff's right. The very speaking of such words, apart from all damage, constitutes a wrong and gives rise to a cause of action. The law in such a case, as in the case of libel, presumes and in theory allows proof of general damage. I then wanted to show you the key passage in Thornton, which you...
I know time is short, but you are saying, when you cite Ratcliffe, that the boundary between general damages and special damages in defamation is different from what it is in, let us say, the law of personal injury.
Well, there is an analogy in that in personal injury you get it's general damages for the trauma you suffered, for what you've been through, what's been done to you. Which
Pain
is
and suffering and loss of immunity.
Yes.
Is the
Yeah, precisely. But
pain injury.
But the dichotomy between special damage and general damage is something that is discussed in Ratcliffe. But you're saying it's different from the general law.
Oh, it's paragraph 25 of our case where we cover what is actual temporal loss. Now, in Thornton, which is tab 32, I wanted just to show the key paragraph at it's electronic 1189, it's the same bundle, and it's page 687 of the bundle. And Mr. Justice Tugendhat, after going through the common law methodology of the words complained of, what is their single meaning, what is their meaning implying the single meaning rule of, most recently adumbrated by Sir Anthony Clarke in the Janes case, and then in those meanings, are they defamatory? And he goes through what defamatory means and concludes that it is about a tendency or likelihood, and the claimant, and one sees that at the end of paragraph 93 on that page, the last sentence said, the claimant does not have to prove that there has in fact been an effect upon him. And then this very important paragraph at 94, there's a further point to be noted if my conclusion in paras 90 and 92 is correct. If this is so, then it explains why in libel the law presumes that damage has been suffered by a claimant. If the likelihood of adverse consequences for a claimant is part of the definition of what is defamatory, then the presumption of damage is the logical corollary of what is already included in the definition. And conversely, the fact that in law damage is presumed is itself an argument why an imputation should not be held to be defamatory unless it has a tendency to have adverse effects upon the claimant. It is difficult to justify where there should be a presumption of damage if words can be defamatory while having no likely adverse consequence for the claimant. Court of Appeal in Jamil declined to find the presumption of damage was itself in conflict with Article 10, but recognized that if in fact there was no or minimal actual damage, an action for defamation could constitute an interference with freedom of expression, which was not necessary for the protection of the claimant's reputation. That, of course, then is the Jamil abuse strikeout. Then, final 2 points. First of all, dealing very, very quickly with the additional grounds of appeal, the Dingle argument, which is really the only substantive point of law, doesn't arise on our construction. If it does arise, this was never the case for the appellants to argue the point. No evidence was adduced before the judge of any overlap of readership, and he was asked to make no findings of fact. So there are no findings, in any event, upon which the court could consider whether or not Dingle should apply. The other point, particular point arriving on the repetition rule, this also does not arise as something that comes into actionability on our case. But Mr. Price's argument overlooks the fact, as we saw yesterday with Section 2, that the law requires his clients, if they want to succeed in a defense of truth, to prove as true the meanings of the words arrived at by operation of the repetition rule, not the meanings of the words arrived at by the particular person who decided to inflict an adverse effect upon the claimant. The test of how you can defend a libel claim as true is still governed by the repetition rule. So it makes no sense that the repetition rule could be used for one purpose and not for another purpose. And then my very final submission, the appellants contend principally that Mr. Lachaux failed at the trial before Mr. Justice Warby to prove any actual adverse consequences of publication, and therefore he has no cause of action. So his claim would be one of those that Parliament intended should not be brought. They would fall into the trivial class of cases and he would have no redress. And you have in your core bundle, volume 2, at page 314 and page 331, the articles as they are now still up on the internet. Searchable public database about Mr. Lachaux. And if one takes say, page 314, this is core bundle volume 2.
This is flag 8, is this?
Sorry?
Is this flag 8? Because
No, it's your page 122, and it's electronic page.
is that the bundle numbering?
Yes, bundle numbering 122. So what is still up there and will be up there until a court orders otherwise is this short update recording that Mr. Justice Mostyn concluded that Mrs. Lachaux was not a victim of abuse, threats, or violence. And then the rest of the article, if you go over the page, is the article that was originally published, an article which is Mrs. Lachaux's story, which the judge has concluded to be false. And then the same with the Evening Standard. It's hard copy bundle, page 137. It's electronic bundle, page 331. There's that same little update. And then there you have the whole story about the assaults and cruelty of Mr. Lachaux, which had been held to be false. And the position that's taken by the appellants here is that they will not take it down because the claimant cannot prove a likelihood of serious harm from those remaining up. And as I say, he will only get those articles down when he gets to the end of the road in this very, very long drawn-out case and is able to get a court order. And just in that regard, just to borrow the words of Mr. Justice Tugendhat in a case of Clark and Bain in 2008, he said, "The web makes alive the old cliche that today's newspaper pages are tomorrow's fish and chip wrapping. Nowadays, the things in a newspaper are more like tattoos. They can be extremely difficult to read." So I'm now going to, if I may, pass over to Mr. Basuto.
Right, Mr. Basuto, you've all of 11 minutes left.
I'm just going to grab the lectern, my lord. My lord, I'm conscious I've only got 15 minutes, perhaps
No,
13.
you've only got 11 minutes.
11 minutes. Well, I'm going to do this at some speed then. My lords, can I invite you please to turn back up section 1 of the Defamation Act so we can focus on section 1.2 now. It's at electronic bundle reference 509, page 7 in the Joint Authorities Bundle Part 1. And it reads, and I suppose one has to read section 1.1 first. A statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. 2, for the purposes of this section, harm to reputation of a body that trades for profit is not serious harm unless it, the serious harm, as Lord Justice Davis read, and I think learned friend Mr. Price also said, it, the serious harm, has caused or is likely to cause the body serious financial loss. Now, the first point that ought to be made by way of introduction is obviously this is not a Section 1.2 case. Section 1.2 only applies to bodies that trade for profit. Mr. Lachaux is clearly not one of those. So in a sense, it's not directly engaged. I mean, one is only looking at really to test out what we're saying about Section 1.1. And I suppose one would say also that no relevant facts have been found by the judge. And of course, we all know, most recently expressed in the Altimo and Kyrgyz case, that the court generally takes the view that if one is working on the basis of assumed or incomplete facts, that's not usually a very good idea to deal with novel and important points of law. So one has to be a bit, in short, what I'm saying is one has to be a bit careful and focus on the contingent aspect of Section 1.2, where it would seem an unusual idea if we were to try and resolve every aspect of Section 1.2 today. So with that in mind, I also point out that the judge said nothing about Section 1.2 at all. Lord Justice Davis mentioned it on only 3 occasions, and the most significant reference was at paragraph 82.7 of his judgment, where he said it may be that in some respects a position with regard to bodies trading for profit under Section 1.2 will be different. I say nothing about that subsection, which clearly is designed to operate in a way rather different from Section 1.1, although he didn't elucidate how he saw it might be different, but there we are. But subject to those caveats...
Serious harm in subsection 2 clearly refers to the same concept as is referred to in subsection 1, because it says for the purposes of this section, it's telling you what serious harm is, or some of the things that it is. So you accept that the word serious harm is used in the same sense in the 2
Yes.
subsections.
My submission on that, my lord, is that Section 1.2 introduces a further hurdle, a further condition for bodies that trade for profit. In other words, everyone has to satisfy Section 1.1. Section 1.2 requires bodies that trade for profit to satisfy another condition. And the condition it requires them to satisfy is also something about the nature of the harm to reputation. In Section 1.1, it's about the gravity of the harm to reputation. In Section 1.2, it's about whether it's caused or likely to cause a body serious financial loss. So that's what I say about that, my lord. But with those caveats in mind, the first point I'd make of two is that there is nothing in Section 1.2 on any reasonable construction which is incompatible with the respondent's proposed construction of Section 1.1. As Miss Page has been elucidating it. And point two is that properly understood, and I think I've just made this point, Section 1.2 mirrors Section 1.1 in that it takes the existing common law of defamation, which already, in effect, as I shall explain as quickly as I can, requires a trading corporation to demonstrate as a condition of having a cause of action that publication of the words complained of as a matter of their meaning has caused it some financial loss or the likelihood of such loss, and raises the bar, takes things up a notch by requiring it to establish that the publication of the offending words as a matter of their meaning have caused it serious financial loss or its likelihood. So, my lords, in order to understand that, one has to look briefly at the common law position. And happily one can take that from one authority, namely the case of Jamil in the House of Lords, 2007, which we've already looked at. My lords, it's at tab 23, Joint Authorities Part 2, Electronic Bundle 921, Bundle Reference AB 419. And the point in that case was a contention by the defendant publisher in that case that all corporations should be required to prove special damage in order to have a cause of action at all in defamation. And that was rejected by a majority, Lord Bingham, Lord Hope, and Lord Scott in the majority, and Lord Hoffman and Baroness Hill dissenting. And I'm going to take it from the head note for the sake of speed, held that under current domestic law, a trading company which itself conducted no business but had a trading reputation within the jurisdiction was entitled to recover general damages for libel without pleading or proving special damages if the publication had a tendency to damage it in the way of its business. That despite the central importance in the convention regime of the freedom to publish free from unjustifiable restraint, the right protected by Article 10 was not absolute and might be qualified by restrictions prescribed by law. The Strasbourg jurisprudence accorded a wide margin of appreciation and in any event did not regard the current rule as necessarily inconsistent with Article 10, and that accordingly no revision of the existing rule was required, and further seriously injurious statements could be made against the company's general commercial reputation and its standing could be lowered by a damaging libel, that a company's good name was a thing of value which it was proper for the law to protect, and since it could not adequately protect itself by other means and would be unlikely to be able to prove financial loss through the issue of proceedings, and I'm going to explain that because it's slightly opaque, a company claimant with a commercial reputation within the jurisdiction should not be subject to a different rule from that applicable to an individual claimant. And the explanation for that rather opaque phrase is that through the issue of proceedings is that paragraph 26 of Lord Bingham's judgment, and that's at page 436 of the bundle 938 electronic reference. And Lord Bingham says there, and this is his primary, these are his primary conclusions on the point. First, the good name of a company as that of an individual is a thing of value. A damaging libel may lower its standing in the eyes of the public and even its own staff, making people less ready to deal with it, less willing or less proud to work for it. If this were not so, corporations would not go to the lengths they do to protect and burnish their corporate images. I find nothing repugnant in the notion that this is a value which the law should protect. Nor do I think it's an adequate answer the corporation can itself seek to answer the defamatory statement by press release and so on. Secondly, and this is the point, secondly, I do not accept that a publication, if truly damaging to a corporation's commercial reputation, will result in provable financial loss. since the more prompt and public a company's issue of proceedings and the more diligent its pursuit of a claim, the less chance that financial loss would actually accrue. Now, because of the time, I'm not going to turn up their other lordships' speeches, but if I can just give you the references, it's paragraph 95 and 102 in Lord Hope's speech, and paragraphs 120 and 125 in Lord Scott's speech. And then finally, before I move on from Lord Bingham, I would simply flag this point, rather 2 points. If one goes back to paragraph 14 of Lord Bingham's judgment, as part of the reasoning about the current domestic law, he cites Lewis and Daily Telegraph in the House of Lords. Lord Reed pointed out that a company cannot be injured in its feelings, but only in its pocket. There was, however, no challenge in that case of the principle laid down in South Hetton, which was not cited in either party's printed case. But it's the dictum of Lord Reed that matters. And then if one goes on to page 373, paragraph 16, although it's quite a long paragraph, and there's an indented quote from Lord Keith in the Derbyshire case. That was a case about governmental authorities, but of course the court looked in obiter at the underlying position in relation to trading corporations. And there's Lord Keith saying there at 547, the authorities cited above clearly established that a trading corporation is entitled to sue in respect of defamatory matters which can be seen as having a tendency to damage it in the way of its business. So what I deduce from that, or what I take from that, is that there is already a common law requirement, irrespective of section 1.2, that unless a corporation can satisfy these conditions which are referred to there, it has no cause of action. And that was the position that common law is the position subject to section 1.2. And then finally, I should just, because I'm just going to refer to it briefly, if one looks at Lady Hale's speech, which in dissent, at paragraph 157, so that's page 973 electronic, 471 of the bundle, and Lady Hale's proposal was this. She says, as none of the authorities cited by Lord Keith was binding upon this House, and the question of non-governmental corporate bodies was not before the House, it is open to us to take the matter further. It would require very little amendment to Lord Keith's formulation for us to reflect the recommendations of the Fawkes Committee. Thus, for the words, which can be seen as having a tendency to damage it in the way of its business, we could substitute, which can be shown to be likely to cause financial loss. So that was Lady Hale's proposal in the minority in dissent. So my submission, my lords, is that is the background, that's the common law. So then one has to consider what exactly has section 1.2 done. And one can say that, particularly, I mean, the bits from Lord Bingham that I've read, but it goes through the whole majority. They're setting out a very clear policy underpinned by powerful reasoning, which I would submit if Parliament had intended to reject or overturn, one would expect section 1.2 to embody or indicate a commensurately clear statement of intent. And our submission is it just simply does not. So against that background, and I'm very conscious of the time, I'm going to do it as quickly as I can, my lord.
Certainly are. You're
Yes.
over your time.
So, my lord, I've made the point that it's a further condition. It's all claimants have to show section 1.1. Bodies that trade for profit have to show section 1.2. It's something about the nature or quality of the harm to reputation that we're talking about. It might be thought that the word, certainly it took me quite a long time to work out, and maybe it was just me being dim, that the pronoun it refers to harm to reputation, not publication. So what I take from that is the two are inextricably tied up. Parliament could have said publication if it had wanted to, it did not. And we say that is significant. And obviously I've said what I had to say about what the law was before this section. The next point is the significance of the observation that section 1.2 is concerned with the nature or quality of the harm to reputation is that section 1.2, in common with section 1.1, is concerned with the nature and character of the specific words complained of as defamatory, and with the effect or tendency of their words as a matter of their defamatory meaning. In this case, it's not the gravity of the words, but their propensity or tendency to cause the claimant body serious financial loss. The fourth point, my lords, is that, as I've explained, it's already a condition of the law that only words which have a tendency to damage a company in the way of its business, are actionable at all. So we say, as I said at the beginning, that this is simply building on that requirement. And I think I can probably cut short the rest of the debate by just turning out one further thing, which is the account given in Gatley, which is in the pink bundle, right at the back. So it's tab 10. I mean, I would turn up the authorities if I had more time, but I think this will probably have to do for this purpose. And it's, so it's tab 10, electronic bundle 1954, internal pagination 112. And this is the part of Gatley dealing with corporations' right to sue. And as it says there, trading corporations. A trading corporation or company has a trading character, the defamation of which may ruin it. And then it cites Jamil, footnote 81.
Looks as if you may have written this, Mr.
No,
Busuttil.
I did not write this passage. But if it's wrong, I'll be corrected.
Very well, proceed.
Going on to the next page with the extraordinary footnote, it starts, accordingly, it may maintain an action for libel or slander for any words which have a tendency to damage it in the way of its business. And the reference there is Derbyshire, which we've just seen. And going on to the text again, and it is not necessary for it to prove special damage. And of course, that's citing Jamil. Now, if one looks at footnote 84, about 4 lines down, there's a reference to Baroness Hale, and it says this: thus Baroness Hale at 157 seems to have favoured adopting the recommendation of the Faults Committee that a trading company should be required to show that the words were likely to cause it financial damage. Indeed, there is very little distance between that and the present law, since the company may only recover damages without proof of actual loss if the words have a tendency to damage it in the way of its business. See the Derbyshire case. So the point they're making is that Lady Hale's proposal in that case, which was obviously not tied up with special damage, is really not very different from the common law. She wasn't proposing, she wasn't adopting the view that it should be special damage. And then going back to the text of Gatley, however, by virtue of the Defamation Act, when it comes into force, a statement will only be defamatory when it refers to a body that trades for profit where serious financial harm is caused or is likely to be caused by the words complained of. Although a company cannot be injured in its feelings, only in its pocket, and an injury must sound in money, the injury need not be confined to a crude loss of income, for the company's goodwill may be injured. And there is a citation of Lord Reid and Lewis, and also, interestingly, a cross-reference to Section 6 of the New Zealand Defamation Act 1992, in which, to cut a very long story short, they have, in that jurisdiction, in that provision, it reads as follows: proceedings for defamation brought by a body corporate shall fail unless the body corporate alleges and proves that the publication of the matter that is the subject of proceedings, A, has caused pecuniary loss, or B, is likely to cause pecuniary loss to that body corporate. And in short, my submission about that is subject to the word serious, that's pretty much what's in section 1.2. And what the Court of Appeal, the New Zealand Court of Appeal, said in that Midlands Metals case, which is also in the pink folder, is that was effectively ratifying the common law. So what I'm essentially saying is that this is also ratifying the common law, but it's moving it up a notch to show that it has to be serious. And then finally from Gatley, if proof of actual damage were required, the causative link between the libel and a downturn in trade might be difficult or impossible to establish, and that's well-established law. It's there in Jamil. So I go back to my main submission. One would expect to see something pretty clear if the intention had been that Parliament wished to overturn the policy and logic of Jamil. There is nothing in the Act to that effect. In fact, and this is my final word on the topic, is that if one looks at the explanatory notes on this, it's paragraph 12 of the explanatory notes to the Defamation Act 2013, page number 523, AB 21, it reads as follows: Subsection 2 reflects the fact that bodies trading for profit are already prevented from claiming damages for certain types of harm, such as injury to feelings, and are in practice likely to have to show actual or likely financial loss. So this is the Gatley point, the footnote point, about what's the difference between that formulation and the common law, subject to the word serious. The requirement that this be serious is consistent with the new serious harm test in subsection 1. And unless your lordships have any questions, those are my submissions on section 1 too.
You managed to secure an extra 7 minutes.
Well, I'm very sorry, my lord. I did my best.
No, don't worry about it. We're an indulgent court. Now, Mr. Price.
I have 30 minutes. Time is not transferable either from my opening or from the time.
No, it certainly isn't.
As brief as I can. If I can just deal firstly with section 1.2. It's really very straightforward. Your lordships were taken to what Lord Bingham said in the Jamil case. It's going to be very hard for a trading corporation to prove financial loss. That was the argument that was run by the parliamentarians who were objecting to section 1.2, citing what Lord Bingham had said. And if you go to the more detailed extracts from Hansard, which you can find in the footnote of the appellant's case, where I deal with this issue, as opposed to the Annex 2 to the respondent's case, where they set out all the parliamentary materials, you will see that argument failed. Clearly it's failed because Parliament has clearly required corporations to prove serious financial loss has been caused. So this actually supports the point that has caused actually does require something to have happened. The relevance of section 1.2 in the present case is how it may impact on section 1.1, and what's significant here is that it's accepted by the respondent that has caused and is likely to cause must mean the same in both sections. I had understood from the respondents, well, if that's not what they've said in my submission, that clearly must be the case, and that's what Mr. Justice Warby observed in the Peertech case. They must mean the same in both sections. I had understood the respondent's case to be accepting that a trading corporation would have to prove serious financial loss, but that it could be inferred from the extent of publication and the nature of the allegations. And that they were saying in relation to an individual in section 1.1 has caused a large tendency, but has caused in section 1.2, you have to prove it has been caused. Well, that can't work. It's absolutely clear that Parliament was intending trading corporations to have in fact proved financial loss. In the same way, it's clear that they were requiring individuals to have proved, by whatever means, that they had suffered serious harm to their reputation. And a tendency is not sufficient on either of those facts that require proof. Just very briefly, since it was raised by my learned friend, it's not relevant to this appeal, but the defendants continue to publish the articles because they believe that it's in the public interest to do so, and that will be tested at a subsequent trial. There's been no findings on that. It also happens to be the case that Mr. Justice Warby did find that the continuing publication of the articles online was not likely to cause serious harm to the claimant's reputation. And it's not just the reference to Mr. Justice Mostyn's judgment, which is clear at the beginning of the article. From the moment of the complaint, there was an addendum put on to all of the articles to record the claimant's more particularised denial of the allegations. It's a classic case of reportage. Don't have to deal with that now. There's two subject areas that I was intending to cover in reply in the light of the respondent's submissions. The first was why the appellant's proposed construction is not incompatible with any other statutory provision. And the second, if I get the time, was why the respondent's construction of has caused is clearly contrary to Parliament's intention. So let's go straight to the other provisions that were said to be incompatible by Miss Page yesterday, the first one of which is Section 2, the truth defence.
Sorry?
The truth defence, Section 2. She went through a list of provisions that were said to be incompatible. That's tab 1, authorities bundle, AB7, electronic bundle 509. There were two subsections, 2.3 and 2.4. I think the suggestion in relation to 2.3 was that this was somehow incompatible with a requirement to prove serious harm to reputation in section 1. I couldn't really understand the argument. This is a truth defence that turns on the gravity of the proved and unproved imputations. An exercise which looks at them in the abstract and assesses their relative moral gravity. Certainly not inconsistent with the appellant's interpretation of section 1. What is far more material is that section 2 is directed to the imputation conveyed by the statement, whereas section 1 is directed to the effect of the publication of the statement. In relation to the abolition clause, section 2.4, well, section 2 is a wholesale codification. No more common law defence of justification. Same applies to sections 3, honest opinion replacing fair comment, section 4, public interest replacing Reynolds. That's why the common law defences are abolished. Section 1 is not abolishing the common law on whether a statement is defamatory. It is simply erecting a further hurdle. This was dealt with by the judge correctly in paragraph 46 of his judgment, which is tab 5 of the core bundle, page 66, or electronic bundle 256. Next is section 8, the single publication rule and limitation. I accept that it is possible, at least in theory, but unlikely, that the cause of action would not accrue on the date of first publication, and therefore possible that the limitation period for the subsequent publication would expire before the first. The issue would only ever arise if a claimant took the risk of issuing outside the one-year period from the first publication. That's the first thing that would have to happen, which would be rare. Why would the claimant take the risk? Secondly, the court would have had to have concluded that serious harm had been caused. Otherwise, the issue is irrelevant. Next, it would have to decide that it was possible that this arose at a later date than, at an earlier date than 1 year prior to the proceedings having commenced. Then it would also have to decide not to disapply the limitation period, which is a wholly general equitable discretion that it could exercise if it chose to, which would get rid of the problem. Getting through all those hoops, it would then have to form a view on the balance of probabilities as to whether the harm or the likelihood of it happening, because the cause of action can be triggered by its likelihood, as well as it having happened, whether either of those triggers happened at a time that was earlier than 1 year before the proceedings were issued. And it is a fact of life that in relation to torts that involve loss, sometimes you have to make those judgments. But my submission, this possibility is more theoretical than real, but more importantly, because this is a case about statutory interpretation, I do not accept that this oddity is capable of detracting from the very clear and ordinary meaning of section 1. It would not be reasonable to infer that by looking at section 8, you can infer that Parliament was really intending a tendency test in section 1 so that everything could tie up neatly and law students wouldn't have any problems thrown at them on this issue possibly in the future. Next section to look at is section 14, which is slander. The appellants have never submitted that harm to reputation is equivalent to special damage, the latter which requires proof of causative financial loss. I gave some examples in footnote 27 of paragraph 43 of the appellant's case that Ms. Page referred to yesterday, of ways in which evidence of reputational harm could be acquired. None of them amount to financial loss. The Thedon case, which I gave as a possible example of an obvious case of serious reputational harm, did not involve provable financial loss. The claimant did not come to court saying, I've lost my job, or I've lost job opportunities which I can calculate in monetary terms. So, one has to accept that these are different concepts. And bear in mind, we're only looking at section 14 as a guide to how we would how we can evince an intention from Parliament in relation to section 1. All slander claims have to involve words that are defamatory. Whether or not they're actionable per se, they've got to be defamatory in the first place. All section 1 does is simply create an additional hurdle in this regard, irrespective of whether special damages must also be proved. Maybe, it will be with some slanders, there'll be a further hurdle to prove special damage. Mr. Justice Warby addressed the fallacy of the respondent's submissions in this regard at paragraph 62. This was in the context of section 2 of the 1952 Act, but it applies in relation to this provision as well, which wasn't brought up by the respondent before the judge. So paragraph 6, I'm not going to go to it because I've got a limited amount of time, but you can see how the judge deals with it. He nails the point, if I may respectfully say so. And paragraph 62 is at tab 5, page 70, electrical bundle, page 260. It may also be worth noting in passing that slander claims involving unchastity to a woman, that's the 1891 Act, or imputations of contagious and infectious diseases, are very rarely encountered, if at all. To rely on section 14 to interpret the meaning of section 1 would be an extreme case of the tail wagging the dog. I then move to the 1952 Act, tab 3. I start at page 36, hard copy 538 electronic, section 2. This was the section that's addressed by Mr. Justice Warby. That still has value, that section 2, for a slander claimant, provided the claimant can show serious harm to reputation. Won't have to show special damage. Next we move on to section 11, another provision which is almost never encountered in practice. Prevents reliance on an indemnity in certain circumstances. And this is the first of a series of provisions which are relied on to say that they won't work unless you can freeze frame the cause of action at the date of publication and solely have a tendency test. I would suggest there's no difficulty in a court determining, should the matter ever arise, whether a person knows that the matter is defamatory. You can know that it's defamatory because it's obvious that it's defamatory. It's an obvious case of serious harm. Or perhaps he knows of some obvious consequence that is going to arise of a serious kind if the publication is made. It may be harder to prevent maybe harder to run arguments that someone should be prevented from relying on an indemnity if what is defamatory is ratcheted up. But is that such a bad thing? And is that a reason to interpret Section 1 of the 2013 Act in a different way? Surely not. This provision remains workable. So does Section 1 of the 1996 Act. That's the next tab 4, page 45, or Electric Bundle 547. Section 11C, that gives two options. He did not know and had no reason to believe that what he did caused or contributed to the publication of a defamatory statement. Then we move on to the offer of amends defence in Section 2. I wholly endorse what my learned friend said to the court about the importance of this regime. The way that it works is a defendant makes a formal offer of amends. If the claimant accepts it, as the claimants invariably do, the claimant gets everything that he could get by going to court. And it incentivizes defendants to make the offer and claimants to accept it. But the provision which learned friend relies on is one that is very rarely encountered. It's what happens if the claimant chooses to reject the offer. So it's Section 4, failure to accept the offer of amends. And in that circumstance, the claimant takes upon himself the burden of proving malice effectively, when he could have had vindication by walking through an open door. It may be harder now to show that a defendant knew or had reason to believe that a publication was both, or statement was both false and defamatory. That may not be a bad thing, but perfectly able to reach conclusions as to the mental state of a defendant in circumstances, for example, as I say, where it's obvious that serious harm will be caused or there's some very obvious consequence of a serious kind that will ensue from the publication. The second, I've finished on that subject area. The second subject area is why the respondent's construction of has caused is clearly contrary to Parliament's intention in relation to I've made submissions on that, but I'd like to make a few more in the context of what my learned friend submitted yesterday. It's quite clear that the respondent's case is that the words has caused serious harm to reputation are determined solely by the defamatory tendency of the imputation conveyed by the statement. But there is no qualification in the wording of Section 1 as to what can be taken into account in relation to whether serious harm to reputation has been caused. It would have been very easy to have used wording if Parliament was simply raising the Thornton threshold, thereby preserving the imputation conveyed by the statement as the only factor relevant to whether it's defamatory. It may just be helpful, finally, just to consider the sort of circumstances that could or would arise if, as a general matter, you wanted to inquire whether serious harm to a person's reputation had been caused. Obviously, what the claimant has been accused of would be one circumstantial factor. That's the imputation conveyed by the statement. To whom is the imputation being communicated, both in terms of numbers? Is it to one person or is it to a large number? The importance of their relationship to the claimant. Is it being communicated to the claimant's employer or people who do not know him and have no contact with him? Who is making the accusation? Is this someone who is extremely well respected or someone with little credibility? What is the existing reputation of the claimant? Does he already have a bad reputation in the same area of the imputation? Are the people to whom the imputation has been communicated already aware of it? These are all potentially relevant factors depending on the nature of the case before the court. But the respondent submits that everything apart from the nature of the imputation can only be relevant to damages or jamil. He submits that the alternative is an anything goes approach. Well, the appellants accept that it is an anything goes approach. That's what Parliament clearly intended. Anything that is relevant and proportionate to the question of whether serious harm to reputation has been caused in the particular circumstances of the case, which must reflect the infinite variety of circumstances that may come before the court in a defamation claim. As suggested by the court yesterday, I referred only very briefly in opening to the legislative history and extracts from the debate. This was on the basis that Section 1 was unambiguous. If the court is thinking that Section 1 may be ambiguous, given the huge amount of work put into it, its key role in rebalancing defamation law, I think I ought to record that accepting the respondent's construction would plainly fly in the face of what Parliament thought it was doing when enacting Section 1. There's an explicit statement that I referred to yesterday from Jonathan Ginogly promoting the bill in the House of Commons. That Section 1 was not adopting the Thornton tendency test because it was too abstract. If Section 1 is unclear, that statement satisfies the Pepper and Hart admissibility criteria.
So you're letting your voice drop. I missed your last
Yeah, sorry,
comment.
I'm very sorry. I referred yesterday to the explicit statement of Jonathan Ginogly that it's not a tendency test, and that they weren't taking on board what Mr. Justice Thornton has said in Thornton. And that's a submission being made to you that all this is doing is taking on board what Mr. Justice Thornton said in Thornton and adding a little more, that it's a tendency test. Well, there is an explicit statement from the Minister promoting the bill that is not what Parliament is intending to do. So if your Lordship is thinking, it may possibly be ambiguous, then I would rely on that statement as being admissible.
Yes, thank you.
I'm very sorry for not making that clear. It's one thing not to communicate to the back of the room, but I've got to make
Can you
sure.
just remind me of the electronic paper?
Yes, yes. It's. I'm taking it from the supplemental bundle. It's in various sources, which is 1866.
Well, if only it was paginated in that way.
It's internal page 22.
Okay.
It's the second paragraph. It was in response to a specific question. Perhaps we can go. I'm going to probably go to this anyway. So I'll take it from the supplementary bundle. I've got hard copy, page 24. I've got electronic bundle 1866. Internally, it's page 22. Second paragraph.
How does it begin?
I'm sorry, my lord?
How does it begin?
The honourable
It
member.
begins,
Honourable
the
member for
honorary
Newcastle."
member for
Yeah.
Newcastle underlined.
Yeah, carry on.
Perhaps I could just invite you to read it because it really is very clear. Mr. Justice Warby also referred to this answer as fortifying his conclusions. There are also numerous references to all the circumstances being relevant. And building on Jamil. Building on Jamil can only be if all the circumstances are relevant, because that's what Jamil is looking at. It's multifactorial, looking back from the date of the determination. Lord Leicester's original bill explicitly referred to all the circumstances. That's at internal page 2. A proposed amendment at committee stage to identify the extent of publication, something that on my learned friend's test would be irrelevant, was rejected as not being necessary because the court would have regard to all the relevant circumstances in any event. That's internal page 24, bundle page 26. I can ask the court to go to that page, please.
Internal 24.
Internal 24, yes.
Thank you.
It's the penultimate paragraph. Turning to the amendments in this group. While we're here, it's also
Who's speaking?
that's Lord McNally promoting the bill in the House of Lords. While we're here, it's also interesting to see that Lord McNally gives an example of a case that was decided against the defendant, but he's of the view that it may well be decided for the defendant after the bill comes into force. Jonathan Ginogly in the Commons gives the same example. It's a case called Mardas, and it's a Jamil case turning on the extent of publication. The case involved Alex Mardas, known as Magic Alex, who was an associate of the Beatles in the late 60s. The case is reported in the EMLR's 2009-8. I do have a copy here, but the only relevance, in addition to what's in the Hansard report, is that it doesn't say what the allegations are in Hansard. The allegations were that he was a con man and trickster who'd spread lies about the Maharishi Mahesh Yogi, with whom the Beatles were associating at the time, and that this had led to the breakup of the Beatles. These are allegations that would clearly pass muster under a Thornton Plus test if you say that someone's a confidence trickster, con man and trickster, who'd falsely claimed to be an inventor. That wasn't the issue, the meaning wasn't the issue. What the New York Times said on this Jamil application was that there was only 177 hard copies of the article and approximately 31 hits online, and it all related to matters that had happened some time ago. That submission found favour with the master, but it was overturned on appeal by Mr. Justice Eadie, who held that there was a real substantial tort, and observed that a few dozen is enough to found a cause of action here, although the damages would be likely to be modest. What is the significance of this? Well, as my learned friend submitted to you yesterday, she said this is precisely the sort of case that should be allowed to continue, even if the publication is small. If the meaning is sufficiently serious, the claimant's entitled to vindication, damages might be small, but those sorts of cases should be allowed to proceed. If my learned friend's construction is adopted, there's no mechanism for the court to deal with a case like this, because Section 1 will not be building on Jamil. And the only relevant circumstance will be taken into account will be the meaning. So once you have a defamatory meaning, if it goes to one person, even if it relates to something that was 40 years ago, all those other factors that bear in mind would be relevant, would not be relevant with Section 1. For Section 1 to have an effect, it's got to be building on Jamil. As I said at the outset, different people can form different view about the extent to which someone in that position, where there's been a small-scale publication, should be required to prove harm in order to obtain vindication. But Parliament considered the matter and legislated in sufficiently clear terms with respect to my learned friend at times yesterday afternoon. She effectively was submitting that Section 1 is a bad thing. It would be much better if we just kept it on meaning determination. Everything would be more straightforward and less costly. The final point is this. If the court forms a view that the judge was correct in his construction of Section 1, and I would respectfully submit that his analysis was impeccable on that subject, but it is possible for a judge to get one thing right and another thing wrong.
I don't think you need to labour that particular point.
And therefore, if the court is persuaded that any of those four other points that I made, which was not applying an obvious test, factoring people who get to know the claimant after the event, not discounting because the allegations were reported, not taking into account the previous publications making the same allegations. If there's any merit in Any of those points, of course, the judge's determination would be open to review. There will have to be a trial in this case in relation to the Section 4 public interest offence in any event, and it would not take a great deal of time for Section 1 also to be determined at that trial, if necessary, by Mr. Justice Warby. My clients would not object to that. Unless I can be...
Thank you very much
Just about
indeed.
done it in time.
Spot on.
Unless there's anything, let me just check if no further assistance, those are my submissions.
Thank you very much indeed. Well, I'm very grateful to Council for their submissions and to those, of course, who contributed to the preparation of the written cases. We'll take time to consider our judgment, and it will be produced in the usual way. The court is now adjourned.